What is the matter? That's not the matter. What if I take the order in court today?
For refund section
Relating to
there will
refund.
apply that pre percent 115 is automatic. The
Yeah.
interest GST.
Give us a GST. Man.
I am applicable of the for 5 years.
Okay.
I said rules only.
Oh, this is in relation to a refund.
Refund, sir.
So we must,
Specify a report.
can you just recapitulate the facts?
The refund application was filed but before the state authorities. The state authorities will not rejected my refund application on the ground that SFI of Kolkata has sent.
Oh, subsequently it says there is no pending, there is no pending.
And my learned friend, Mr. Mishra, was kind enough to take that instruction. So also my learned friend for appearing to SFI.
True.
In the first case, in addition to this SFI objection, there was another objection that it is barred by limitation under section 54.
Well, 54 does not apply.
Not apply
Because it was a precondition
months.
deposits.
My on the last occasion, my submission was depending on the Supreme Court order that 107 subsection 6.
54 and 107 deposits are completely different.
Months. And for 107 6 deposits, 115 is applicable. That would be in respect of the first case, please.
This will take very report.
Okay. Look, at this juncture,
Still one line.
So let's see, so far as that interest portion is concerned, your let's see, as per rule 89, your let's see about as per rule 89, interest to final application. So he's
So what application? We have set aside the order, keeping the application alive, who have been treated in that way. Now you have to disburse the amount.
Whatever is claimed, that will be.
Sir, section 115 is very clear when the refund flows in accordance to section 1076.
Your Lordship.
Automatically 115
Is
accompanies.
Your Lordship.
That is what Honorable Supreme Court has also indicated. So what?
So what we have simply said so. Go there.
But so far as the portal is concerned, whatever is.
That's your internal mechanism that you'll have to calibrate the same in the manner as is required. Go there. No, cannot be done.
Non-application of mine, taking cue of mechanical application
Very frankly, we have not gone into that aspect.
Your Lordship.
If the SFIO has said that there is a pending or an ongoing investigation which is against the petitioner, what was the reason for rejection? You could have kept that application in abeyance until you get the final nod from the SFIO.
Your Lordship is.
Rejection is proper. What are you talking about? Cannot be done.
Your Lordship.
We have not gone so deep into the matter.
I'll bow down on that to Your Lordship. I bow
Sir,
down.
that cannot be done.
Your Lordship.
Yes. Go on. Let's call the next matter.
Item number 2.
next matter.
All the
We
four
will pass
matters,
that.
all the four matters.
These are all these sub-items are the.
Only for SFI.
First item.
The first item is
The first item is limitation.
dealing with SFI.
All of the matters only SFI.
So we have already said the limitation, when it does not apply, then it does not apply.
Sir,
In view of this, in terms of this order, all other cases are.
Your Lordship. Yes.
So what is this?
We study this same time. We will pass.
So sorry for that bit inconvenience, Your Lordship. I'm so sorry. My intention is not.
No further action has arisen within the jurisdiction of this court.
Item number 3, that's
Item 3, sir.
Chief Director State Council to obtain instruction whether there is a due pending or not, sir. The NGQ has been lifted. No NGQ is left, my lord. Petitioner has lifted all the NGQ. Yeah, my lord,
Then what remains?
nothing, my lord. So the petitioner can now apply for surrender. No, we want apply for surrender.
Yes, apply for surrender, what more?
That has been rejected.
Why?
But at that time, it was rejected in the month of February. That time, Lord, NGQ had not been lifted. Subsequently, now he has lifted. So,
I will apply for surrender now because what for the due? The surrender means 30 days notice. 30 days notice I gave, applied to surrender.
No, Millers. That Millers.
That time he is saying something impossible.
No, Millers. Annexure 1 and 2, Millers may see, he had applied for surrender in the month of January by giving 1 month's notice. He had not.
That's true. What he says is that at that point of time, you may have taken a plea that the NGQ has not been lifted by them.
Yes, please.
Now, the question is that now it is an admitted position that the same has been lifted. Now he does not want to continue. He wanted to surrender the license. Now he says that the law is that he'll have to give a 30 days notice. So today, if he gives a 30 days notice, but the renewal is offering on the expiry of tomorrow.
No, Millers.
What?
The term is expiring tomorrow. It was expiring tomorrow, but now, Millers, there is a direction from the government that all liquor shops, CL shops, their tenure has been extended by 2 months.
So that is what he does not want that extension to come.
Now
How can you compare this to first week, Milord? I have
Now
special
it
right to
is
surrender.
extension.
What is this? Never such kind of arguments, never applied by
It's not a
any
question of
What is
argument.
this?
I'm giving the order. My next
Number one cases, after applying for surrender, they deposit money and surrender is accepted. Now the first time is such a
was rejected. Now there is deemed extension, so he can apply. So I'm not standing in the way. He can apply, Millard.
Why should I apply, Milord?
That
I
was
have
rejected.
given the money.
Well, previously it has already been rejected because MGQ was not lifted. He could have lifted the MGQ and applied to surrender. He did not. Now he has lifted, so we can allow the surrender. Not an issue. Not a problem. But my lords, we see this is the order of the government, my lords. All liquor shops throughout the state, my lord, their tenure has been extended by 2 months. So he can apply.
What is his obligation under the extended period?
But
That
my
was-
other side
Just 1 minute.
has not
Just
seen
1 minute.
49.
What is his obligation under the extended
My
period?
lords, section 49, my lords.
What is his obligation?
My lords, to give 1 month's notice.
I am giving you, then during
And-
this 1 month,
Yes.
for these 2 months, is he not required to lift?
No, my lords.
For these 2 months, is he not required to lift?
Yes, he's required to lift, my lord.
That is why he says, I do not wish to lift.
But my lords, he cannot bypass the statute. My lord, this is
But
section
the
49.
thing is that the court, the litigations, when it is ensured, the court cannot overlook that particular subsequent event that has happened. And if the subsequent event suggests that there has been a compliance to the great extent, then in that event, why
There
the
is no
court,
compliance.
why the court will go by a technicalities? Why not
There is
do a
some
substantive?
similar- there is-
Here is a case, you may have rejected, your rejection may have been correct. But now because of the subsequent event, if the application is not made alive,
My lord,
then where he will
the
stand?
statute provides a 1 month period, my lord.
So that is his notice is already there, kindly visualize.
1 month is for the authorities, my lord, so that no vacuum is created, my lord. We require 1 month time, my lord, to put everything in order. That is why that 1 month is for our benefit, not for the petitioner's benefit.
How can he sell it? What do you do with that? Have you thought of?
My lord, the 1
He
month.
discontinues the business.
Yes.
He discontinues. He lifts the MGQ for this 2 months or whatever. Then what will you do with that? Have you thought of?
No, my lord, that.
What will you
We
do?
cannot, my lord, we have to act
Yes,
according
sir.
to the statute.
No, what will
Let
you?
me see what is the
Sir,
law.
statute may be, sir, it has to be workable. You have to make out a
Yes.
workable
If
proposition.
my lord comes to that conclusion, I would.
What will you do?
But my lord,
Just tell us.
my lord,
Just tell us what will you do with that goods which he will lift. He discontinues the
There is
business.
provision for that. Millard, that can be settled with the next person who comes, Millard, to the steps into issues. That can be, that is a subsequent, Millard, happening. But as of now, Millard, the statute provides.
What are you proposing, sir?
No, Millard.
He has not read section 49(2).
If the petitioner surrenders.
He has not seen 49(2). He is rewriting provision itself.
No, not at all.
1 second, Mr. Rao. 1 second, Mr. Rao.
Exercise.
Lord, kindly see section 49, A and B. Kindly see, Lord. He is trying to rewrite section 14. Kindly see.
Yes.
Any holder of a license or exclusive privilege granted under this act to manufacture or sell an intoxicant may, unless his license or exclusive privilege is liable to cancellation or suspension on section 47, surrender the same. A. On expiration of 1 month's notice in writing given by him to the collector of his intention to surrender it, and B. On payment of the fees payable for license or the consideration money due for the exclusive privilege for the whole period for which it would have been current, but for such surrender. Not what does it mean? Means end of the year. Today, if I give a notice, I will have to pay the whole MDQ and license fee for the till end of my license period, which I have done it. After giving a notice, I have paid it. Not their duty. 1 second.
No.
Their 1 second, Mr. Raj. Their duty is after I supply for surrender and notice, they will have to give me a notice, put me a notice that this is your due, you pay it for the purpose of consideration of your application. Instead of intimating me the due, the state will rejected it saying that you have not lifted. But I lifted it. Kindly see, what for the whole period?
My license expires on 31st of March.
And my license expires on 31st of March 2026. Before that, I will have to clear it. I have cleared it. Whole period. Meaning that what he is saying is, if you reject it, then I will have to give 1 more notice. Then for that 1 more notice period, I will have to lift it again. For that 1 month, I will have to lift again. Meaning,
That is why I was contemplating my mother also.
Yes. May I place section 49 once again?
Yes.
Any holder of a license or exclusive privilege granted under this act to manufacture and sell an intoxicant may, unless his license or exclusive privilege is liable to cancellation or suspension under section 47, surrender the same. Now, my lord, section
Means what?
47 says, my lord, if it is liable and if it is not liable under 47, then he can surrender. Now, my lord, this petitioner, his case was liable under section 47, which says, my lord, 47B says, my lord, if any duty or fee payable by the holder has not been paid.
Did you cancel it? Did you suspend the license?
I did not, my lord, the language says, if it is liable.
I'm telling you, then, brother, then I am inviting your attention to two judgments of the Supreme Court. One is the Nageshwar Majumdar's judgment. I think the Savita Dev versus Nageshwar Majumdar. The another judgment is Alita D'Souza's case. The word in the statute was that if it is terminable, the word terminable connotes liable to be terminated. The Supreme Court interpreted, since it is not terminated, no protection on the premise of terminable arises. So one has to give a judicial sanction to it. It is liable for cancellation or suspension under 47. Have you cancelled or suspended under section 47? No. If no, then you are not entitled to take advantage of it. Can anybody bring that Alita D'Souza's judgment? Find out.
If my lord's proceeding that premise, my lord, I would not.
That is what was held. That is what was held.
My lords, I got, I should not tell you. But my lord, sir, if that is one aspect.
I'll give one more notice, then I'll have to leave for that month. Within that month, if you cancel.
That's why we wanted to keep that application alive. For that reason, taking aid of the subsequent event and for reconsideration, so that at least they can take a conscious decision in view of the present facts.
There is no deal.
There is whatever. So that is what we wanted to just make it.
That's right.
But he is standing in the way. No, you have to make a fresh application. Extension is done, which is, I do not know. It's a.
I am saying, my lords.
Is a unilateral extension is permissible, or it is a mutual parties must agree for extension?
Parties must agree, but in excise matters, they do not take any consent. They unilaterally do it. Bound.
Why I'm saying, my lords, is, my lords, when he had made the application for surrender, at that time, my lords, dues were there. MGQ had not been lifted, dues were pending, it was rejected.
So there are line of judgments which also says that at that point of time, there may be a situations, but subsequent events, once it has happened, then in order to do a substantial justice, the court can definitely take into account. Here is a case that a person who is an unwilling person, who does not want to continue, he says that whatever my statutory liabilities are, I'm ready to pay off to the government so that they will not, there is no, the burden on the government exchequer. I have paid it. Now I do not want to continue. You settle it to somebody else, I do not mind. I have paid off all my liabilities. Here is these kind of application.
No bar, my lord. In fact, it should be allowed in all probability.
Then,
all I'm saying is not let him make a new application.
Why new applications? Then again, there will be a further liability for a period of 1 month. Because that will be today, if he makes an application, then his obligation for the month of, say, April, that would arise. They have to list and they have to pay.
And if you again reject it within that period, another 1 month, again I'll have to lift. My learned friend is not forcing that.
Yes, I do understand that. But
Povitra Kumar Roy versus Alita D'Souza. Lord, that's AIR 2006 Supreme Court 3355.
AIR
2006 Supreme Court 3355.
Read that judgment.
I have already.
Justice Mathur and Justice Quintus.
Interpretation of Section 3 of the West Bengal Premises Tense here.
The fact is, my lord, we have not cancelled or suspended. So, my lord, I am not even going there, my lord. That fact is there, my lord. I cannot change it. All I was saying, my lord, is that 1 month period, if the authorities are not allowed 1 month to make arrangements, a vacuum will be created. That is my only, my lord, saying. That is the intention why, my lord, this 1 month period was there in the statute itself. It has been incorporated in the statute. So the authorities get 1 month time, my lord, to allow things to be put in order. So for that 1 month period, my lords may always say that the MGQ.
You take a decision now, this is there, this is a subsequent event, on the basis of that, make a further considerations, decide the matter.
My lord. I was only, my lord, I was only trying, my lords, to. But my lords, if my lords will direct, my lord, that will obviously.
Copy at page 11, my lords.
Very next page.
Impugned order is in vernacular. That's the reason I find a translated copy, page 11. It is to inform you that as on the date of your application or surrender of your license, you have neither lifted the entire MGQ as per your license for the year 25-26, nor you have deposited equivalent amount of duty against the balance quantity of fixed MGQ. Since the excise policy of page 10 is in vernacular. Now let me clarify it. Let me read it by translating in vernacular. But this is to inform you. 25-26 is 31st of March 26.
Yes. Malad, I have the undertaking.
We are due by 25-26.
Which undertaking?
Before it.
We are given undertaking, my lord, that as and when the new policy will come, he will abide by the terms of the new policy. I have given my lord's notes.
If you get 400, there is 68 minutes that you put in an undertaking that license will pay the warrants before nobody says the 25 minutes.
As no policy has not come obviously for the year 24-25 and for the year 25-26. And that already been reviewed.
Yes, 25-26 is existing license.
I will be abiding by all the policies.
For 25-26.
25-26. Yes.
Not 26-27. 25-26. In fact, 25-26, there is no new policy. It is 24-25 extended to 25-26.
Because there was no policy for 25-26, my lord, it was in anticipation here. Now it is not.
January.
Yes.
In January.
Yes.
Yes.
So,
Because of an undertaking now, this in relation to the preceding year.
Preceding year, my lord, but when it was renewed, my lord, for that particular year, there was no policy. So, my lord, therefore, this undertaking was given.
Has not been published, but however, at the time of the renewal, you have submitted an undertaking that you will abide by this clear definition about implementation after the new policy notified in 2004. I do not know sentence.
Kindly see.
Since as on day, as on published, application cannot be considered.
Kindly see page 16.
and I just the opinion ready to go till now. 24-26 year. Policy or the same policy. Podcast
Okay, on that ground.
That's the point.
No, on that is not on that ground. It is primarily, my lord, because of the MGQ ground.
Sir, kindly read this.
It is
যেহেতু অধ্যাবধি 2025 ବର୍ଷର ଅବକାରୀ ନୀତି ପ୍ରତ୍ୟେକ ପାଇନାହିଁ କମା ତେଣୁ ଆପଣ ଦେଇଥିବା ଦରଖାସ୍ତ 28/1/2026 ରାଇଟ ବିଚାର ଯୋଗ୍ୟ ନୁହଁ 25-26 ରେ ଆସିନାହିଁ ଏକ୍ସାଇଜ ପଲିସି
25-26 excess policy is not there.
2026 ରେ ଆସିନାହିଁ
25-26 excess policy is not there.
18/2/2026
Policy is there. It is page 68, my lords.
sir
Lordships are correct.
26 is rejecting. He is saying that 25-26 policy has not yet come.
Kindly see
So your application is rejected. How can this be permissible?
page 68, my lord. Policy, excise policy of 24-25 is extended for the year 25-26 with the same terms and conditions.
Yes, my lord. My lord, what the
So how can you say that
the
policy?
purport is, my lord?
We are not on, sir, we are on this rejection reason.
I'm explaining.
Reason for rejection.
I'm explaining, my lord. No, that is not the reason. The reason is
Reason. That text, if you read, it relates to 25-26 policy only, and he is under the notion that 25-26 policies have not yet come on.
my lord, the amount of
You heard it.
my lord,
Sir, there are. I have to hold up yours.
this is not very nicely worded, my lord. I do understand my lord's predicament. This is
Translated course. The first sentence which you are heavily relying on is really a reflection or recapitulation of the fact,
yes.
but not a ground for rejection of an application. There are two aspects. One is what transpires in course of adjudication is a factual one. And the second part of any adjudicatory order is what are the reasons for which you are determining. First sentence, if I go in this translation, simply says, it is to inform you that as on the date of your application for surrender of your license, you have neither limited data and as per your license for 25-26, nor you have deposited the input amount of balance quantity of SMG. Matter is a full stop. That's a reflection or recapitulation of the fact that since when the word starts with the since,
Yes,
it goes to the determination part. Since the excise policy for the year 25-26 has not been published, but however, at the time of the renewal, you have submitted undertaking that you will abide by the new excise policy and pay the differential amount in the year. After the new excise policy such and such is notified and coming forth, that is why I say sentence is hard. That since as on date new policy has not been published, the application submitted by you cannot be considered. What is this? Is only on the basis of the new policy having not published. Is it a correct name?
Translation
Very bad.
new policy.
When you start a sentence with a since, then you'll have to give after a comma the conclusion.
You need to for the reason, not the word since. Since is the wrong word. For the reason. That is for the reason, not since. No, there is no new. Let me correctly read the translated version. For the reason, as on date, 2025-26 policy has not been published. That's all.
Yet not been, yet what the third teacher?
Yes. Adhyavadhi has not yet been published for the year 25-26. Therefore, your application is not considerable accordingly.
You have translated that. I go by a translated version.
Some mistake in your translation. One mistake.
One word.
2-3 words.
That changes some of entire reasoning.
I can translate it and read it before my notes. It's a
Yeah, I am misreading.
No, your lordships are correct.
Don't say to.
No, your lordships are correct, Lord. I beg excuse for the mistake they have committed. Your lordships are correct. Well, the thing is, sometimes we are not very meticulous in watching the translated version.
25-26 only.
Some of my associates have done it well. Some of my associates have done it.
Here, my lord, it is more clear, I think. Here they have written about the MGQ.
Which order?
My lord, page 12. This is in English.
The earlier order of 32. And this is the order from
18.2. This is also their challenge. Yes. Yes, my lord, that will prevail.
Previous order.
The subsequent order will prevail, my lord.
13.2, they are asking me to lift, and I have lifted.
13.2 they've asked.
It has become infractional because you have lifted.
I have lifted.
So there's no question of quashing of this order.
No, this order is not required to be quashed. We have complied with this order.
Yes, my lord, they have lifted now.
Well,
That I have.
I think this undertaking is punished. Last paragraph to read. Yes, divided by 25, 26.
There.
Please,
rigid, no?
you are relying on this.
Liberal man.
Development is very serious. We are all never argue with this. You know,
That is a typographic. How can I say, my lord?
at the very outset, we must record
Item number 4.
Okay.
My application.
What is the application?
No, this is the challenge that you lordship had heard. It's regarding to the tender.
What is
So-
The application that is there, this is a challenge I'll indicate, but may I just first start with the order that was passed, the recording of what had happened on the last day. Look, this is your lordship's order of 18th of March 2026. Look, the tender pertains to upgradation of railway coach toilets of a particular kind, which if I'm not mistaken, AC coaches. Now, LHV toilet here. Look, paragraph 1 of the lordship's order of 18th of March is also going to assume some significance. In terms of the Railway Board circular of 25th November. Okay. Paragraph 4, my lord, is going to be my next round of challenge.
Instructions for
Yes.
Yes. Lord, two dates, if I may just beseech your lordships to make a note of. A first tender is floated in October 2025. The work value, the nature of work, what is to be done, and the technical requirements are naturally there and are identical to another tender which is floated later. In the first tender, I am a L1 bidder. I am 13%. So if I'm looking at the numbers for about 84 crore work value, there's a difference of about 22% between me and the L2 and L3. I am 13% lower and L2 is 8% higher. So by the number, the difference is about 16 to 18 crore that the government exchequer is saved on. This tender is not cancelled. I am declared as the L1 bidder sometime on the 2nd of January 2026. A fresh tender is floated on 26th of January 2026. Again, the work value, the nature of work, all technical requirements are the same, except one particular clause is added, which is clause 1.1, ostensibly stated to have derived its source from one particular railway circular. My rejection that has come is not on the ground, which is why your lordship said record in paragraph 1 and I say it's important. The rejection is not on the ground that I have been in breach of clause 1.1. My rejection is a one-liner that I am in breach of the 25th November 2024 circular, my failure to upload technical certificate. As if I had not given anything. We assail this before your lordship, sir. This order of 18th of March is passed. It was required for them to come and ideally show these two things. One is my rejection was bad. And secondly, why this tender? First one was cancelled.
Why you participated in this?
Yes, the second, so I'll come to that.
Participated.
Correct.
If
So
you
I
say that the cancellation was bad, you were declared as L1. What was an occasion
to participate again in the second one. So may I just first,
Can you take a risk?
I will
Rebound and then say that.
say the first one. There's a question will come up probably of estoppel or waiver. That bit of it.
Waiver, no, the estoppel of the accusants.
That's right. So similar to that because I participated, I'll just look at it therefore from the reverse picture. I'll first try and show to your lordship that my rejection in the second tender.
I can understand that you wanted to take the analogy from there, that if it is a replica of the earlier one, and in the earlier one you were not debarred on a technical aspect.
That's the point.
Then in that event, in the letter, how can you be debarred?
That's the point, which is
that is.
Yes, so I am actually putting the cursor a little ahead. Your lordships are absolutely right. I am not placing the cursor. So I am saying that this rejection is improper because there has been no difference and the rejection is not for my breach of clause 1.1.
No, there may be situations that in an earlier you have submitted everything, you may have omitted to submit the other documents in the second.
But that case is
so that
yes,
is a possibility.
Yes, but that case is not made up.
It cannot be said to be a conscious, but maybe an omission. Voluminous document.
First one I had, yes. But the case is something else now. Once they come up with an affidavit.
I think one senior counsel who appears on the last occasion, he was highlighting many things before us.
Yes. I'll just take your lordship through that. On the last occasion also, I had come and addressed your lordships on these issues. They come and say now giving an affidavit that out of 3, I have admittedly given 2. Of the repetition 187. Bidder, if I may not, bidder has not submitted technical certificate RB letter number so and so, Miss 12. So this is the ground on which I have been rejected. Now, my lord, if I may just one arduous task, if I may just beseech the court to undertake with me, please compare page numbers 158 with page number 173. 158 is the previous tender work which was tender document, and 173 is the new tender. Well, let us say wall area, complete repairing, FRP panel, all of this. 173 same. Your lordship will take any serial number of the court's choice and compare it. It is identical, including the technical certificates that are required, like MMDS 20046. If your lordship looks at serial number 6, MMDTS 18008, it's same. Identical. Look, why I'm showing this is because there is no difference in the work that is to be done and what is required to be given for this work. Only difference that comes in the second tender, which is now their stand to have to justify cancellation of the first, is what your lordships will find at page 187. I'm sorry, it's a key further. 180. If your lordships compare 180 with 164, which is also technical criteria, special technical criteria, it's identical till clause 1.1 that comes in. This, they say, was not in the first. According to them, it was a mandatory requirement which skipped their notice in the first one. Therefore, they cancelled that and floated this.
Yes.
1.1, my lords will just have a look at once. Technical certificates. As per Railway Board letter dated Miss 12 dated 25/11/2024, Annexure 3, para number 3. All, now their understanding of what the letter says, all technical certificates, including FST, that is fire smoke toxicity requirement, for paneling material, epoxy flooring, wash basin shall be uploaded with offer. Last sentence, please see, in the absence of any of the above, offer will be technically invalid.
There's one more sentence which you missed on.
No, then I'll read the whole thing.
Yes.
OEM authorization letter along with technical catalog of OEM shall be uploaded with offer. OEM means original equipment, manufacturer having requisite documentary proof, plant and machinery. If I come back to the first bit, all technical certificates including FST requirement for paneling material.
Which page?
180, placing 1.1 only again.
Yes.
Technical certificates as per Railway Board letter.
Just now.
Just now. No, I'll coming back only for one aspect that they now said in their affidavit. Three things the lordship will find are mentioned. All technical certificates including FST requirement for paneling material, epoxy flooring, wash basin. Now the affidavit has come, I'll show that paragraph, that for epoxy flooring and wash basin I have given. Apparently I have not given for paneling material some other key certificate, FRP, something called an FRP certificate. But my rejection, as your lordships have correctly recorded in paragraph 1, is not of breach of 1.1. It's of the breach of the 25th November 2024 memorandum of the railway, which my lords will find at page 188. Now, because 1.1 refers to annexure 3, para number 3, that you'll also find at page 200. My first.
The 1.1 refers to a particular railway.
Yes, which is at page 188. No, look, after that, you'll also
Which is what they have reflected in rejection order at page 1.
That's right.
So if the reference of that railway board letter is there in 1.1 and those is also reflected in the rejection order, then what does it connote? We are non a reference of 1.1. Does it mean that it has not been done in the 1.1?
No, I don't say that.
So
look, I am saying that this 1.1 at page 180 refers to 25th November 2024.
isn't what is also one
Annexure 3, that's right.
87, the same letter.
Yes, now annexure
Letter
3,
one.
that's the letter.
So
And now your lordship will just compare this annexure 3, para number 3, which is mentioned in clause 1.1 as FST certificate, including fire safety requirement for paneling material, all of that.
yes,
Whether that is there in 3, Roman 3.
the original letter.
The circular of 25th November 2024 starts at 187.
Okay.
This annexure 3, para number 3
187
of the requisition.
So that is the rejection order.
No, 188. 188. I'm sorry, not 188.
You are talking about 187.
Sorry, 188. Just one after.
Yes.
This is the 25th November 2024.
Correct.
Annexure 3, Roman 3, which is referred to in 1.1, is at page 200.
70, page 170.
200. 200 of the writ petition.
Yes.
Roman 3. The clause 1.1 refers to annexure 3, para number 3 of the 2024 circular, which your lordships will find at page 200.
Yes.
Yes. 200, please have a look at it.
Annexure 3, Roman 3.
Yes. At 200. FST requirements. May I not your lordships have it?
Anti-gravity.
Yeah, that's right. Anti-gravity, scratch resistance, and other quality parameters related to mechanical properties, hygiene, and safety are the prime requirements, and accordingly, qualified material complying related specification drawings and remarks of this letter shall be followed, and accordingly, technically capable participants shall be selected as per works contract eligibility. Please mark this note. Works contract eligibility as per technical criteria given for individual items. This technical criteria for individual items is identical to this one as it was on the last one. It is nobody's case that as of the last one, I have not uploaded those. So if I have to sum this up, the rejection now in the affidavit, I'll show that the rejection ground is the FRP. Some certificate called a FRP certificate I have not given. Fiber reinforced plastic certificate. That's FRP certificate I have not given. This FRP certificate, your lordship will not find anywhere in page 200. My ground for rejection is I am in breach of this 25th November 2024 circular. They refer to annexure 3.
No, I understood.
And the FRP paneling, that's serial number 1 at page 173, 158. Same. Both the tenders. First one I'm L1, this time I'm out. Just go FRP to give me that affidavit now. If your lordships are 173, please have a look at once. And 158, please just once compare here. Same, complete repairing of existing FRP panels with water-based filters, resins.
Which one? Serial number 2?
Serial number 1 at page 173. Complete repairing of existing FRP panels with water-based filters and resin supply application so and so MMDTS 2046 latest having anti-graffiti, all of that. This is the new tender. Please have a look at page 158. It's the old tender. Same. In that one, if I was technically qualified becoming the L1, then wait, now if I may please once put it in the question, lordship will forgive me.
Just one and submitting clarifying one. They have yesterday served a copy of this regender. They filed a regender to state. If you taken care of it in the course of argument, then I need some time. If they are ignoring this, then lordship will go ahead.
The rejoinder is something, but it's nothing. It's a reiteration of the whatever.
I cannot bring something.
That your lordship will ignore. Look, I'll tell you, lordship, why that was required. After we had that hearing on Friday, your lordship was pleased to keep it today. we were served with 140, 150 rejoinder again by the respondent.
Not
Additional count.
You can't file the additional affidavit.
Additional count.
Document.
Another 150 document is given to us.
The other way, maintain transparency by submitting all documents, the court do not be confused.
Anyway, Lord, I'll bring it down to the conspectus is very, very narrow.
Not stand. Section as well.
Lord, I will have to rely on the additional documents that I've disclosed.
I think let him rely, that will not change the course of the argument. Let it go.
That's absolutely fair, Lord. I'm very grateful to my learned senior.
Yes, let it go.
Then we can just. Because I'll bring it down to a very, very narrow perspective. I'm restricting it to this. Because I am.
Yes, I understood. That gamut of the argument says that if the subsequent tenders and the previous tender are one and the same as a replica of one another, except there is a 1.1 clause is inserted by virtue thereof. Certain railway board letters have been this is not really some is a way of relating how successful or your decision was valid and even a presentation where you were declared as a valid.
Look, I'll just take my.
What you wanted to say.
I'll take it slightly.
According to you, if they talk about, then this Roman 3 simply talks about FST.
That is the point.
And not FRP.
That is the point.
That is what you say.
That's right.
And therefore, how can they borrow this notion of FRP in their counter?
That's it.
They cannot travel beyond the scope of the terms and condition of
the tender. That is the point.
So you are taking hovering around here and there and going there, going to some other place.
My mistake. my mistake. Your lordships have identified the issue absolutely to the T. I am trying to now say.
Does it capable of being crossed?
I'm sorry, Manoj.
Capable of being crossed.
For T for travel. Yes, now, Manoj, because if I just have to now take it a little further and marry the ground of rejection to the tender, the rejection your lordships have noticed is not of 1.1. The rejection is of the 2024. The tender only refers to 3.3. Now, one aspect of the discharge of the first tender, to what extent the court can do a judicial scrutiny or review of that.
After your policy.
After participation, also I'll indicate why.
Sure.
Because now your lordships have held.
Because we have held otherwise. Cancellation, interferences permissible under what grounds? We have said that on these grounds, the cancellation order can be interfered with by the court. But we had no occasion to consider where a subsequent new tender was floated and he participated. What would be the effect of such action, the conduct in relation to the same?
The only aspect of the lordships are possibly looking at it from the aspect of acquiescence.
I am with our own judgment.
Yes, I am not on that. I am citing the judgment only to showcase that your lordships can look at the ground for cancellation. I'm not saying
we will definitely, because it is not a decision which is amenable to be scrutinized. It is a process by which the decision has been arrived.
That's it. Then I don't need to cite
that reference you wanted. I just thought that you are showing cancellation order was bad.
No, the reference I want to draw. It is the reference that I want to draw.
What I already indicated.
So when you 1.1, then I don't need to cite that decision. No, then I just show 2 paragraphs from the affidavit and conclusion. But one thing you know, just have a look at page 10 of the counter filed by the railway.
What is that?
Page 10. Paragraph 13. First one coming down. Page 10, you know.
Yes.
In the instant tender, this is page 10, line about 5 from top.
Yes.
In the instant tender,
They admitted that we have submitted this
FST. The petitioner has submitted
But
buyers
she want such and such.
and not uploaded documents pertaining to paneling material, which was the rejection of the bid of the petitioner. The paneling material includes FRP walls of the toilet, which form a major portion in the tender work. I've shown item number 1. FST they have admitted have given. This paneling material has no reference in Annexure 3, Article 3 or that II paragraph 3. My rejection is on that ground that I have not complied with that.
Yes.
Same. But this stand is against. I don't want to again repeat it. This is the stand consistently they've taken. Admitted that I've given. Now the other aspect, if your lordships are with us, then invoking certiorari, please direct the railways to produce what certificate did this L1 and L2 give. Because we specifically know that these certificates were not given by L1. I am putting and sticking my neck out, impose a 1 lakh cost on me. Impose that cost on me. I have taken instructions. Kindly call for the records. Check if the certificate was there. These certificates that I have been found to be folly of.
Very bold.
Very bold, Vinod.
Yes. He has come up with a very bold assessment.
Last occasion, whatever.
He is ready now. Once he says, if I have not submitted FRP, whether the L1 has submitted FRP.
Can I just say a sentence?
If it is so, please come bring the record show.
But FRP is not a requirement at all. But FRP is not a requirement. Milord, I can satisfy
When he is taking a plea,
But FRP is not a requirement at all.
has he submitted the FRP?
Lord, Lakshmi, kindly see the tender condition.
No, I understood that.
Lord,
condition.
FRP is a material, not a certificate.
Oh,
My lords, may kindly consider FRP is not required. FRP.
The railways is the answering respondent here. My lord is saying, I don't know who is appealing for.
FRP.
I don't know.
Lord, I am appearing for the L2.
L2 anyway is L2. L1 is
can't confuse the call.
L2 does.
You can't
No,
confuse the call.
please don't say all
Try to confuse the
but not awarded a lot.
But I can address on the proposition of law.
You are also challenging something on L1.
But L1
If
is.
he is eliminated, your right to
My
fructify.
lords will kindly consider. FRP is not a certificate at all. He is just trying to filibuster. He is just trying to filibuster. Kindly see, FRP.
Let's understand.
Right, my lord. Kindly see, Lord, page 118.
How the
Kindly turn to page 180. What is the requirement? There are twin requirements, my lord. One FSM and one OEM, not FRP. FRP is a material. That's
friend will say this.
don't repeat the.
Don't do that, please. The railway affidavit I have shown.
Kindly see.
My learned friend L2 will not show. Railway affidavit will show.
Just try to don't disrupt. Kindly see page 180.
Let me.
What are the twin requirements?
1 minute. I am reading.
Yes, yes.
Read that.
Yes. FRP is not a requirement at all. Kindly see, ma'am. My lords are going to. once your lordship sees that, my lord.
No, let us see.
Yeah. Your lordship sees that what is
We will
required.
see you later on.
Yes.
You are to be seen first.
Absolutely.
Don't worry.
Absolutely.
Let us see.
No, well, it's what FRP, that is actually what.
No, I understood the language.
DGRF.
The language which is used, let me see.
Yes.
DGRF 180.
This one. Now, I am just asking one thing.
Yes, of course.
There are two asking. In the counter, they do not talk about the certificate. Mr. Senior Roth is also agitated and
I'm not.
very much vociferous.
No, I'm not agitated. I'm just trying to
any kind of a certificate. It is what that the paneling material must include. These kind of that is a fiber reinforced plastic. So this is something, a component must be there. This is what he says.
Correct.
But if we go back to 187,
No, my lordship. I would request your lordship to
talks
say.
about that he has not certificated the technical certificate.
Yes. Yes.
Talks about the technical
Sir,
certificate.
yes, my lord.
This
For
must be
that,
considered.
for that.
What that certificate.
Yes, my lord. I'll point that out for
If
your
the
lordship in a minute.
certificate is relatable to FST,
Yes.
then it is an admitted position that he submitted the.
No, my lord. Your lordship has stated
Railways have also.
that will issue. My
In
lord,
the instant tender, the petitioner has submitted the fire, smoke and toxicity of the epoxy floorings and such and such. So they have admitted FST compliant.
no. No.
How are you? The tendering authority is admitting something has been done. Third party to that document.
May I just point out what is the certificate which is missing, my lord?
Kindly see, Lord, kindly see para 18 of the railway affidavit. Read para 18. What is it?
Only you can clarify.
Yes. Plus, if I come to the additional affidavit, page 19. I'm very precisely I'm clarifying this. For page 19, additional affidavit, page 13, paragraph 19. Page 13, paragraph 19, 19.
18 and 19.
Subcommittee manager, I'm giving the hard copy of this much. That however, the firm has not uploaded any relevant certificate. This is a certificate related to paneling material, which form a major part of the work and acts as a regular interfere of the passengers. And this is basis of which the petitioner was rejected. This is the materials. Let's see, may come to the page 21. Yes, page 21.
Have they sufficient relevant certificate?
Yes, they are getting certificate related to paneling.
I'm asking, what certificate, what kind of a certificate?
Yes, Manoj. May I clarify that?
Let him, the DLG, let him clarify.
Yes, their
What kind of a certificate, what it is expected, please tell us.
Yes, that is, let's see, may come to the page 180 of this petition, 1.1. It is required.
Does it
1.1.
require? Is there any certification which is required? Send me 1.1. We have read at least
Serial number.
time by this
My lord,
in the interregnum.
my lord,
Tell us. It simply talks about the railway board circular and
Serial number
its
2.
entirety,
my lord,
but only restricted to only one clause of Appendix 3.
my lord, I'm just clarifying. I'm just clarifying. Yes, my lord, clarifying.
Page 180.
There is two category of tenders as far the circular is concerned. One is for non-AC, one is for AC. The terminology is this.
We are
For
not
AC, it's
concerned.
required.
We are not concerned. Come
Yes.
to 1.1, what did it say?
Yes.
Please.
My lord, now my question is coming. Once he participates, can they change the tender condition? Once after participation,
No,
we
no,
are changing.
sir. The
Yes.
question is the interpretation of the clauses of the tender.
Yes,
It is not the question that this is onerous, this is wrong, this is bad. If they, after participation, come and challenges any clauses and says it is unconstitutional, it is something I can appreciate.
yes, yes.
They are not saying, they are saying that 1.1 you have brought, no problem. But what 1.1 says and what you have understood is the issue.
Yes.
He
What they
said,
have
I
done.
am strictly within the purview of 1.1. I am not saying that 1.1 I have not complied.
My lord,
Tell us, 1.1 says technical certificates.
yes.
As per Railway Board letter number 2022, miscellaneous 12, dated 25/11/24. Now you are restricting this letter because I've seen the letter contains 3 annexures.
Yes.
Annexure 3, and there also you are restricting further para number 3. So, as per this, you are required all technical certificate, including FST requirement for paneling material. Epoxy flooring was basically shall be uploaded with the offer. You admitted in your opposition counter that yes, there is sufficient FST. No.
This certificate related to paneling material is not submitted. We have disputing ourselves.
Please,
Yes.
come to page 10 of your card.
Yes. Counter attack.
Come to page 10 of your counter, sir. In the middle, starting with the instant tender. Page 10, middle, in the instant tender. Have you got?
Yes, yes, ma'am.
The petitioner has submitted the fire, smoke, and toxicity, that is FST. M stands for fire,
S stands for smoke, T stands for toxicity
Yes.
of epoxy flooring and wash basin.
Let's make complete lecture. And yes,
Correct, I'm coming.
yes.
And not uploaded
The
the
document.
document pertaining to panel materials,
Yes.
which was the basis of rejection.
Yes.
Then second sentence.
Yes.
The paneling material includes FRP, means fiber reinforced plastic.
What?
Walls of the toilet, which form the major portion in the tender work. The toilet walls are prone to mischief and prone to fire and smoke due to regular and frequent procedure use. Now, you have brought the concept of FRP. He has taken two paragraph, annexure 3, paragraph Roman 3, page 200 of the reproduction, which according to this 1.1 applies. Please come to page 200 of the reproduction. Now, sometimes the page has to take a brief for the reading.
Not preferred, Lord. We are there to assist your Lordship. No
That
problem.
is what is happening.
No, your Lordship need not take up. We are there to assist.
What 3 says?
The FST requirements. Yes.
Yeah.
The FST requirements empty graffiti, scratch, resistance, and other quality parameters related to mechanical properties, hygiene, and safety are the prime requirement, and accordingly the qualified material complying related to specification, drawing, and remark of the latter shall be followed, and accordingly technically capable participants shall be selected as per the work's content, eligibility, and as per the technical criteria given to the user. That's why my initial stage I am showing, my lord.
What is this?
This is I am just clarifying. That's my lord. There is two things. One, there is co-chest. Just a minute, my lord.
FST requirement.
Just a minute.
Don't get into that.
I'm not counter. Let's me come to the para 13. There is two things. One is ICF, Integral Push Factory. That tender was different. Then LHB, the Lean Hoffman Bose. That is pertaining to the SE purchase are concerned.
What?
Yes, the L.
Sir, annexure 3, if you count, at least 200.
200, yes.
Detailed guideline for the work of the toilet, both for AC and non-AC is given.
Yes.
That is,
Just above that Roman 2.
my lord, we are missing the point, all missing the point, my lord. My lord, may I just take a minute of your?
We are
But what your
we are
lord?
really stuck up with one aspect.
Yes, my lord.
What
And
is
that
the
aspect,
object? What is the object and the purpose of floating and open tender?
yes, my lord.
The purpose of floating and open tender is to ensure the fairness, the transparent
Absolutely.
and impartial way of inviting the applications so that the best price and a competitive price
And a qualitative product will be obtained.
best price, the competitive price, not compromising on a quality, has to be obtained.
And for that, my lord,
Equal opportunity is given to everybody to participate, to have the contract with the government.
for that, my
If
lord,
price appears to be, there has been a disparity.
but
And it seems that there is a imposition of a burden on the exchequer, then the scrutiny becomes too minute.
absolutely, my lord. Absolutely. What
Too
you
minute to consider if there is a lapses.
My lord,
It's not lapses.
my lord, I'll just point out what your lordship needs to look into here, my lord. At page 180, your lordship has seen one part of 1.1. There is a second part of 1.1, which requires another certification. That's a OEM certificate. Kindly see at page 180.
180.
Yes, my lord. Clause 1.1. Your lordship has read the first part. I will not repeat it. Kindly come to clause II. OEM authorization letter along with technical catalog.
I would have appreciated if the railway comes.
They are not saying. They have said you.
One will justify why I'm out.
Your L1 is something different.
I'm just
The
clarifying.
railway has not come forward.
They have
I
stated.
have not said that the OEM has not been given or the certificate from a manufacturer is not uploaded.
They have
Had that been there,
They have stated that.
the railways have been very categorical in their stand that no, it is only they have not submitted FRP. That is
May I just complete, my lord? May I just complete? May I just complete, my lord?
How can you counter you?
They have.
We're maintaining all transmission filing. Let's see the page 9, paragraph 12 again.
So that is why you are securing the contract at a 18% or a 13% higher than what is quoted to you. Why?
We don't know because we have not financial bid. Only after technical bid we are now in the process of technical bid. We are not touched the financial bid now.
180, page 180.
Yes, 180.
1.1.
Yes, 1.2.
So you are sticking to only italic one, not you are not sticking to 2 or 3, as Mr. Mukherjee has pointed. You are not. You are only 1. 1.1, 1.
1.1.
So FSP.
No, 1.1 and then Roman 1. My brother want to say, not Roman 2 and 3. You should be very clear.
Yes, sir.
We are making it very clear.
Yes.
He's taking a different point,
Yes.
which you have not taken.
One second, I'm clarifying. Let's see for a moment. Let's come to page 9, paragraph 12.
Yes.
Of the counter affidavit.
Yes, we are into that.
Yes, I'm reading that. That it is further submitted that the technical requirements stipulated in the tender, particularly those related.
Page 9, I am coming.
Yes, page 9, paragraph 12. 1, 2.
Just 1. Page 9 is not tallying with us. Sorry. No, my.
Paragraph 12, yes.
FSP.
Yes.
Yes.
I read it. Yes, please.
It is further submitted that the technical requirements stipulated in the tender, particularly those relating to fire, smoke, and toxicity, FST, stands for standards for paneling materials, wash basins, and epoxy flooring. Here is the case, where the incorporated in the compliance with the Railway Board directives and in view increasing the safety concern, including the incidents in railway systems. These requirements are essential to ensure passenger safety and where uniformity applicable.
There cannot be any doubt on these particular
safety measures which the railways are really trying to ensure.
Yes.
Even no sensible man or a reasonable man would stand in the way what you are saying. I think that's the first and foremost duty to see that the passengers, they do not suffer, there should not be any casualty so far as the smoke or a fire or a toxicity is concerned. We are not on that. So FST is a very important one.
But in that part, what he has done, he has submitted wash basin and epoxy flooring. He has not submitted a certificate in respect to the paneling materials.
Contention is that
Yes.
the FST certificate which they are talking about, this FST certificate must be separately given. One for the
Paneling materials.
wash basin,
Yes.
another for epoxy flooring,
Yes.
and third for paneling materials.
Yes. That was not given.
Submitted wash basin and epoxy,
Yes.
but not pre-prep.
Yes.
This is what your
Yes. I'm acknowledgement.
Mr. Mukherjee is taking us.
No, that is what I'm saying. That is also your lordship. At this point, your lordship may kindly call for that record if your lordship wants to please.
And apart from the
The birth certificate is there. We will be depositing 1 lakh as close.
Very good. Just call for the record.
Let them know.
Let both these records now. Keeps it on any day. My learned friends are so aggressive. Just call for the record.
For the record.
I produce the records.
No, I don't have these.
Mr. DSG, we will not leave.
No. I am not asking, my lord. I am ready and undertaking that everything should be submitted to the court.
If
Yes.
there is any cloud or mind
But thing is this.
which strengthen any kind of a favoritism, discrimination, nepotism,
Yes.
I believe we will
My lord,
definitely.
everything is online. We will not do scoop to tampering or altering anything. Everything is online. Whatever document submit, we will submit from the after. My lord, only one thing. It's only one thing.
Three,
Yes.
submit.
But we have to upload it with each system, my lord.
No, sir, the documents have already been uploaded.
Yes.
You have to just download.
Yes. That condition I have. Yes.
Under section 65A and B of the Evidence Act.
Yes, that's the password.
Question of 1 lakh
I
has
have to
come.
make a certification.
Question of 1 lakh from both the sides have come. So very interesting, my lord. I am not there. I am not there in the 1 lakh issue. So let them fight on 1 lakh. Your lordship may take it up on 6th. Let them produce the records.
Yes, no. 6 years.
No.
Well, your lordship may take it up tomorrow.
No. Kindly keep it on 6.
Produce the document tomorrow. Produce the document tomorrow, we don't mind.
So we have to submit it tomorrow. No, we can submit it tomorrow.
Tomorrow? Yes, ma'am.
Only upload to the system and submit it to the court. Nothing is.
Tomorrow.
We'll upload from the system. Download from the system.
Download from the system. Uploading would come. How can you do? Already obtained the assurance from the DSG that he says that we will not proceed any further. But cannot go in this.
Because there is a very emergency. Then they do certain measures.
We don't mind.
Toilets issue. When a matter of toilets issue, so tomorrow let's take, we'll give the document, let's pass it.
It requires, it is always an emergent thing. It requires an emergent.
Yes, we'll extend all, we'll try our best to.
Lord, I am
beneficiary.
purely on the question of law. Lord, I'll just clarify 5 minute time your lordship will give me, Lord.
He will do.
But on the basis of the facts submitted, I'll clarify it, Lord. Lord, I'll just assist your lordship 5 minutes.
Any
But that-
L2 has been included in.
They have included me on the ground of.
L1 and
No,
cartel.
Application they are complaining.
Homogeneity
Clarify,
same
your lordship will
person.
give me 5 minutes.
L1, L2.
5 minutes time I'll
That
pray.
is why this law is
And that's why the
just over.
prompting also for the regulators do not show this paragraph, show that
But
paragraph.
I'll just address your lordship of 5 minutes of the.
My lords,
Give you 7 minutes.
my
Why does that-
my lords, through an affidavit, I'm just putting the LOI on record because nobody has filed it. LOI which has been issued in my favor, I'm putting that on.
It's not necessary.
Just to show the prejudice that I'm suffering.
Simply take note of it. If it is tainted with any kind of a vices,
Your lordship will quash it, obviously.
as we say, that's
Your lordship, otherwise also your lordship will duly compensate me for being dragged into
you have quantified already both of
absolutely. Sir. I'm not wrong.
both of you have already quantified. So yes.
Very grateful.
I think that in view of the cost of the tender, this 1 lakh is too less. So
I do not know both of them have agreed.
Item 18. Nobody is appearing.
Minus 43.
None appears. 3 weeks. Next.
Item number 19. So as the electricity certificate holder, local self certificate holder, local self certificate holder mayor. Just challenge the Annex 1, the judgment of the lead petition.
Yes, give us 30 seconds. Yes. So that's a policy decision. If they have decided to discontinue, and as a one-time measure, they have done it as a junior assistant, LSGD certificate holders, then in that event, how can you accrue a right?
What happened? Not my contents on what happened. Well, the selection list has been published.
Maybe 181 candidates.
Well, no, published, and that has been continued till 2015.
Correct. Why you did not challenge that particular notification when they discontinued in 2015?
Well,
You have to have challenged that.
no, I am not a candidate of that
Could
list.
not be challenged because
I am not a candidate of that
Annex of
list.
6 of the requisition, that 30/12/2015, that says that take notice that a merit list of so and so in the year 2001 on the recommendation of selection board constituted under
Of the certificate, they have been called for and
Correct. But later on, they discontinued this another avenue of getting a job.
what happened, my lord, till that period, there is no new selection list or new new advertisement. So far as the later stage diploma holders, my lord.
Understood. Now, this diploma holder, if they have discontinued that, we will not consider that. Now, you have not challenged the 2015 circular when they discontinued it. How can a court direct the doing of what you wanted that you should be considered on the basis of the cancelled one or a rescinded notification?
I will glance at Anisat Purat.
We have already seen that.
I am not a candidate of that selection list, but due to delay in that selection list, I have overaged, my lord.
Can they relax it?
Yes, my lord. There is this section of municipal rule, my lord.
How far they can relax?
As the 408, my lord. Section 408 of municipal rule 1953, my lord.
Yes.
That
Is it still applicable or it has been obsolete? It has become obsolete?
exceptional case, my lord.
I am asking you whether this rule is still there or it has been superseded by another rule.
Yes, continue. That section is continuing.
The question is not that. Question is that they have discontinued. Your writ petition was not that.
My petition is that due to that several litigations there in that selection list of 2001 minutes. He has no opportunity to apply.
What is your age now?
And
What is your age now?
well, there is press advertisement is there.
What is your age now?
51.
So 56.
56.
What?
56.
What?
It's the lectures of the authority.
No, sir.
56 years of age.
Huh?
56 years of age.
Huh.
He is described. Page 2 of the writ appeal.
There is also read appeal my lord filed earlier also at page 9.
Are they continuing with this? Question is he wanted a relaxation to be done. But his writ petition is filed for his engagement straight away. What is the prayer made in the writ petition? Paragraph 3 of the improved order, something else what he's arguing.
Purpose for selection of the petitioner in the municipal service in class 3 posts complying Annex 2 series by quashing order to the commission passed by opposite button of 3 under Annex 7 series. The 2 series is this. Actually, 2 series is diploma LSGD awarded by All India Institute of Local Self-Government, Bombay, is a desirable qualification that is in 1966.
Nothing, if it has discontinued, discontinued. And the notification says discontinued, not the question of vacancy. Have they floated any advertisement for filling up the vacancy? Have they floated after 2015 any? Now,
Yes, ma'am.
where is that? Show us.
Just. Well, at the Annex 10 also, there is a latest advertisement at Annex page 52, ma'am. That is recently. Well,
No, what is the essential qualification now?
there is a matriculation and the preferential qualification is LSGD diploma.
So that's all.
I am the diploma holder only.
No, I understand. Though, so that qualification is still there.
No, they are not indicating that this qualification is essential. But it as per municipal rule, section 427, my lord, that is a preferential qualification.
No, that is one is a preferential qualifications, but you'll have to have the minimum qualification.
Yes, yes.
That is a says +2 arts, science or commerce. That's the qualification.
The graduate plus LSGD diploma holder.
Oh, I find from page 48 of 2019 is a different.
Well, 48 is at the 2019.
True. Where is the qualification enshrined in the recent one? Where is the qualification?
That particular qualification they have not in.
So that is up to them.
That is preferential qualification.
But there are two things. One is the essential minimum educational qualification, and another is a preferential educational qualification. There is a vast distinction between these two categories.
But he has also that.
Essential you must. Preferential means if you are there, you qualify, then in that the preference would be given to you over the others who do not have. But if you are not eligible to participate, then what?
I'm eligible.
Oh, 51 or 56 years of age. So, no, it's not a latches. No, it's not a latches.
Here also has a class of recognition.
I don't think so.
Annex 5 mailer, so 40% have been appointed.
When?
Page 34.
When? Tell me when?
In the year 9, 12, 15.
So, before the cancellation? After cancellation, what do you mean? Nothing. They have already cancelled.
It's true, but I am the certificate holder of
No, sir.
1990.
This is, no, sir.
That selection is made for 1993 certificate holder. Then
Why you did not challenge that 30th December 2015 notification, which have practically taken you out of the zone because you acquired the diploma after 1993?
that is true, but
That is true.
I am not a candidate of that selection list.
Oh, it is not. When the omnibus cancellation came, then what remained? That means nobody would be considered thereafter, 2015. Thereafter, nobody.
You lost page 9, mine. Page 9.
Yeah, is this?
Page 9. You have filed a writ appeal number 219 2019. The order dated 12/9/19. In view of the aforesaid facts and circumstances, since OLFS rules categorically envisage for giving engagement to the LSGD certificate holders, and though it is considered as preferential qualification,
Sir, take a decision for engagement. It does not talk about any other thing. It was not brought to the notice of the court. We do not know what is there. It simply talks about a consideration. Consideration does not mean appointment. Does it mean appointment?
Para 4 of the counter affidavit. Para 4 of the counter affidavit and writ petition. Signature writ petition আছে।
What can I say?
But as per the direction of Honorable Court, so and so say, a list of 181 candidates were prepared. The petitioner had neither possessed LSGD certificate as a sponsored candidate, nor his name was sponsored by the employment section, nor appeared in the selection conducted by board in the year 2001, for which his name had not been empaneled in the merit list at that time. So after obtaining concurrence from Finance Department and Law Department, appointment under 40 appointment order of 40 candidates out of said merit list, including the petitioners in so and so WPC and other several petitions, was issued by Housing and Department on the basis of recommendation of Finance Department and Law Department. Government had pleased to rescind the merit list.
But in 2001,
At
in that he did not participate.
he did not.
But he says that he has been eliminated because he did not have that certificate or diploma certificate prior to 19. That's a wrong statement made on oath. No, brother, it cannot.
Petition counter.
Unnecessarily violation.
Ah,
The whole difficulty is there.
they came in 2012. You did not.
He came in 2013.
Government, the rates of fee has been decided.
Not there was some contempt was going on. Did they got it. That is the create for the account comes to the if they have some vacancy now. If it's a company,
They have to fill up according to their rules. And
no,
what
they have
are the
to-
definition?
the second, no, that's not. By the time this case was disposed of, that was not rescinded. That's why this order is of 19/6/2015. By then, rescinding order
It
has
was
gone.
not there. That is okay.
That was not rescinded at that time. No, it has come in December. Rescission of
30th December.
30th December 2012.
15.
15. So this order will not to your benefit.
The instant writ appeal arises from a judgment and not Sorry, we not have to make it. It's called the next.
Item number 20.
We have not dismissed any matter. Don't worry.
The next week is
Whatever. Yes.
Item 20.
20.
in item break. In case of items, I have on behalf of the respondent, can I pay for a copy? Will that be included in I can address your option?
What?
And for the private respondents in the secondary appeal. And the third sub item, where is the debit applications. So you will address your option on the issue of.
You are appearing in 468. Your case. No, Mr. Mahanti's case, 468.
In case you lost, I am
Mr. Mahanti is appearing like a veteran. I have already served a copy on him.
So far as the item number 1 is concerned, in that item number 20, the first item which is there in the list as WF 440, I have the instruction to appear and let a copy be solved. So because it has
That is Mr. Mishra's case.
and the next sub item there. The first sub item, Mr. Mahan.
First exchange the copies, then list. Exchange the copies. Next week.
Only problem.
Next week.
Item number 42.
Kindly see.
Item number 42, same judgment again.
Exchange the copies.
Item 42 and one more matter.
Appears. Record the name who is appearing for whom. The copy may be served upon him in course of this week. This is the matter on the next week.
The first one which Dr. S.P. Mishra is appearing.
Please record who has not received the copy in what matter. So please say the next week we are keeping this matter.
Yes,
Item 42 and one more matter which is
42 we don't know who is appearing. So just wait till the 42 comes.
Some matter which are on the bank sheet.
No, Mr. Counsel, the difficulty would be because in that matter, like him, that I am appearing instruction to appear on behalf of opposite party, copy not sir. We don't know. So that's why we are thinking.
in my matter.
If we tag it on that day, he will come and I have not received a copy. Then again, it will be adjourned.
Statement of the law.
No candidate.
No, as far as
But the service has to be affected.
As
If we-
far as 42 is concerned, Mr. Palik's office has already entered appearance. So I will serve copy, let it
Please,
along with.
please do it. Do it.
Condonation.
Yes, 42.
There is a condonation.
There was
Condonation delay.
42.
This is pointed out a 10 days delay.
Oh, we'll see to it. You just give
Which is.
next week. Yes?
Is there anybody from?
Yes, call the next.
Item 21.
Record to some documents either related to High Court cases and Supreme Court, again, law and order, then my name.
What is this?
For my last convenience, I prepared
No, he's asking for a 10 days time.
my problem with my, they have prepared the gradation list in advance with the single staff.
Taking 10 days time. Now, you
Act upon that, whatever.
No, act upon means are they going to promote somebody else immediately,
Yes, ma'am, by that gradation list.
immediately or not?
Yes.
Immediately it is not going to.
It's not going to happen. Then when he's saying it's not 10 days, you will
So
be.
that must be serious.
And I am also giving a comparison to my learned senior, so that
It is submitted by the Deputy Solicitor General that the
Yeah. Yeah, honorable court observation taken. Honorable court from observation.
Who are you, sir?
And
Who is he?
Not opposite part number one. Not aspect.
Who is he?
At page annexed status.
Yes, who is in English? Why?
And 39.
Earlier your petition was withdrawn. Earlier your petition was withdrawn.
नहीं नहीं से वो मैं विड्रॉल नहीं किया सबको.
Earlier your petition you withdrew.
जबकि उड़िया को ही
First petition you withdrew.
He wanted to say in Odia.
सर मैं कहूँ कि उड़िया की पहले पहले मनोरंजन करूँ.
ଆପଣ ରିଟ୍ ପିଟିସନ ଟାକୁ withdraw କରିଥିଲେ କି? ଆପଣ ଯେତେବେଳେ ପ୍ରଥମ ରିଟ୍ ପିଟିସନ କରିଥିଲେ
ଆଜ୍ଞା
ସେ ରିଟ୍ ପିଟିସନ ଟାକୁ withdraw କରିଥିଲେ?
कि କହିଲେ
ନାଇଁ ନାଇଁ ସେଇଟା କରିଥିଲେ କି ନା?
ମୋତେ ଉଦ୍ର କରାଯାଇଥିଲା ଉଦ୍ର କରିବା ପାଇଁ.
ଆମେ ସେଇ ଗୋଟେ
ମୋତେ ବାଧ୍ୟ କରିଥିଲେ.
ଆଜ୍ଞା ବାଧ୍ୟ କିଏ କରିଥିଲେ?
ଅନରେବୁଲ ସିଙ୍ଗଲ ଜଜ୍ ଅନରେବୁଲ ସିଙ୍ଗଲ ଜଜ୍ କହିଲେ ଏତେ ଗୁଡ଼ିଏ କେସ୍ କଲେଣି ତମେ ହାଉସ କାହିଁ କରୁଛ ଉଦ୍ର କର ନହେଲେ ପେନାଲ୍ଟି ଚାର୍ଜ କରିବି.
I'm just filing for your lordship's kind reference.
What kind of this appeal is against which order?
Well, this is against the order of the single judge.
Obviously.
My lord.
Which date of the order I mean? Which order means date?
My lord, this is starting from 2008. We filing the writ petition
This appeal is filed against which order?
against the order dated, my lord, in the review petition number 49 of 2025. That is at
So set aside order dated 17/10/22, 10/11/25, passed by learned single judge in WPC number 21578.
10/11/2025. In review.
What is 17/10/22? He also and a review also.
Now that if we have already decided that is at page 26. In the earlier reconference that you have also kindly see para 4 of the
That we have seen.
my lord, writ petition was filed, that was dismissed, then again he filed review petition.
The review was allowed to be filed for sure.
And your lordship in the writ appeal earlier, second writ appeal. Your lordship may kindly see
This is
the
the order
observation.
how it is applicable.
That's why he is challenging that original thing. This order now he seeks to challenge 1710. Then another one is 1011. Then 1125.
That is a review order. Must be a review order. The certificate copy is this. That's a review order.
So these two orders,
How can it be?
he wants writ appeal. No.
How can it be? Ask him. He challenged that order, the writ appeal where the liberty was given to him to go for a review. Appeal. No.
Okay, this is coinciding.
Review.
Review
12/3 of 2019, I think. Writ appeal. Confirming the 4/4/2018. This is another one. Promotion. No, this is. The appeal which was filed against that, recall, I mean, the withdrawal manual.
Oh, that's right. This one.
This is what it is for. 15 years. He challenged this order in view of the medical appeal.
Yeah, review.
Continuous. Doesn't intra-court appeal or continuation? How to make you understand the difficulties in law? Tell me. The situation is that the parent order by which you withdrew your writ petition was challenged by you in the writ appeal. The writ appellate court affirmed the order saying that there is no merit in the writ appeal. Writ appeal is dismissed.
That order.
Then I do not know, that should not have been. It says that I have dismissed, but liberty is given to go for a review. You file a review application. Review application is dismissed. First question arises. Dismissal of the review is not an appellable order. What to do?
Honorable, our law advocate present.
You understand Bengali? No.
କାହିଁ କରୁଛନ୍ତି ସେ ଆପଣଙ୍କ ବିପକ୍ଷ ପାର୍ଟି ସେ ଏମ୍ପ୍ଲୟର ପାଇଁ ଅଛନ୍ତି
dismiss କରିଦିଅନ୍ତୁ ଆଉ କଣ କରିବା ମୁଁ ଦେଖିଲି ସ୍ଥାନ ନାହିଁ ଆଉ
What is saying?
ସତ୍ୟର ସ୍ଥାନ ନାହିଁ
Are?
ସତ୍ୟ ଲୋପ ପାଇଗଲା ଯଦି କିଛି ବାଟ ହୋଇ ସାହାଯ୍ୟ କରନ୍ତୁ ନହେଲେ ନାହିଁ ଆଉ ସେ ଯୋଉ ଡିଭିଜନ ବେଞ୍ଚ ଅର୍ଡର କରିଥିଲେ ଅବଜରଭେସନ ଦେଇଥିଲେ କିଛି ସେ ଅବଜରଭେସନ ନ କରି ମୁଁ ଆପ୍ଲାଏ କରିଥିଲି ଅବଜରଭେସନ ଯୋଉଟା ଆପ୍ଲାଏ କରିଥିଲି ସେଟା ଅବଜରଭେସନ ଯୋଉ ଆପ୍ଲାଏ କରିଥିଲି ସେଟା ତ ରିଭ୍ୟୁ ପିଟିସନ ସେଟା ଏଇ ଯୋଉ ମିସ୍ କେସ୍ ଗୁଡା ମୁଁ ଯୋଉ ଖାତା
In this case, that reading your topic that is from another parish office.
Submits that,
Allocation and
file it, what ID number, what is this? It's submitted that, another report.
Earlier, the applicant and others,
Where is the order?
the order is annexed for 11. The joint petition was not entertained within the similar.
Where? Page 11 is not, is the prayer. Where is the order impugned?
Page 88. 11 pages, 90.
Order dated 8 January.
Within the same day, joint petition was entertained and thereafter also entertained. And earlier, present applicant and others filed with petition that was entertained. Subsequently, 12% filed separate writ petition that was entertained, but this petition was not entertained. So clearly, the regulation of harassment. We not see also entertaining joint application.
Then ask for a code fee for each of the petitions.
Same day, you will see, with due respect.
No, right now, another petition is filed.
Same day, you will also.
No, if there is one.
Regulation of service and completion of 6 years of service.
Earlier, my lord, 35 persons, including the present. Just in the petition. I saw committee, proceeding you have challenged.
I challenge the proceeding and also annex 8, my lord. That is regulation of.
Many orders you have challenged.
My lord.
Many orders.
No, my lord, page 77, mainly the annex 8, my lord. Page 77.
Annex 8, Annex 9, Annex 10.
Annex 9, on the basis of Annex 9, Annex 8 was issued, my lord. The lordship kindly see the earlier writ petition. Earlier writ petition, page 45, my lord. Annex 5.
No, I'm searching for the cause of action, whether they are all similar
All
or
similar,
identical or emanating from particular order or.
Relate to very Annex 8, 9, the honorable single judge entered in joint application money.
No, in
Relating to very Annex 8, 9.
in Annex 8, many names are there.
My lord. Many persons
There are
also entered.
32 persons are there.
My lord. Out of 42.
Sir, please answer. Please have some patience to listen to me.
There is a court fee.
42%.
How it is attracted?
One order is passed. Answer 8. That is one of the challenges before the writ petition. Right? Now you have come up.
The court fee in relation to writ.
All are ladies, my lord.
17. All are there.
All 17 staff.
All 17
My lord.
are there amongst those 32.
My lord. And 12 out of 32, my
Asking
lord.
you, sir.
Right. Out of 32, 12 joint petition entered by the honorable single judge.
Already
Already entered notice.
entertained.
Out of same transaction, same order.
You have that order?
My lord.
Which one?
That
Who
is
is for the other side?
Annex 12.
Are you supporting this order? Or forget about what has happened. Cannot several persons join together if they have a common cause of action in one? Yes, it's a question of the court fees to be levied thereupon. If it is relatable to an each person, then the court may direct the further court fees to be put thereupon in relation to a number of the persons. But what more? Rejection? Can it be done? I do not know what is the court fee concept. It is relatable to one person or each person or one petition. What is the court fee? Has to be, because I know the other state from where I come, it is each person. And regularly, there has been a multiple persons, we are directing them to pay the court fee in relation to each. Deficit court fee, you deposit. Dismissal. How can you support?
And on same day, my lord.
Don't aggravate.
Sorry.
How can you?
Ms. Saraswati Mahapatra, have you never faced this sort of problem?
She must have.
You are service exponent. You have
No, she must have.
In SAT, in administrative tribunal and administrative tribunal, central tribunal, we have seen. But in High Court also, certain times we have asked for extra court fees. We have been paying that.
It is always an extra court fee. Not maintainable cannot be said. You can join multiple cause of action into one. You can join multiple parties if they have a common cause of action. Yes, sir. We can't accept. But you'll have to pay a deficit court fee. There. You are paid for one. You paid for each individual. Where is the provision in the Court Fees Act?
Here one.
High Court.
Do you have a provision in the Court Fees Act or in the rules? I do not know. Find out the provision and give it to us. Keep it tomorrow. In the meantime, just find out and give it to us.
In your office also,
Yeah.
you must have filed any.
Get the page.
You are not examined.
Separate court fees.
Huh?
According to the direction of the court also.
So that we were doing. I was also doing, but I have never verified that.
Yes.
What? Huh? No, process fees, court fees on the writ. Court fees on the writ. Anyhow, keep it tomorrow as first matter. You also find out when you are arguing the matter, so will you not come with all the laws? Simply blue. You have to come that this order cannot stand on the law. This is what the law is. Other matters entertained, other done, why this is spared. This is the law. Come ready, find out the provisions, give it to me tomorrow.
Item 25.
Reinstatement of a sarpanch.
Reinstatement.
Just 1 minute.
3 points.
Oh, on the basis of a interlocutory application of in a disposed of matter.
That is one. There are 3 points. One is in effect.
What was the original order disposing of the writ petition?
Original order, my lords, is at
Sure.
page number 66, annexure 8.
Where is the operative portion of the order? Direction is aforesaid to be complied with. No, what is the direction?
Direction is at page 71. Near page 89.
No, 71 is something different. Very weak. Disposed of with the direction as aforesaid. What is this as aforesaid? Earlier, what it says?
Let me kindly see the operative portion is at page 70.
Just 1 minute.
First of all, there's a order.
Just.
Some portions interchangeably they use suspension and dismissal.
The court is over. So it was a direction for consideration on the revocation of a suspension.
Revocation, not suspension, removal.
Oh, whatever.
There's error of record. In some places, the Honorable
Sir, I am asking you, you did not challenge this order.
No, this was challenged.
Where?
Before the division bench, and we lost.
So this is to the affirm.
It stood affirm.
Correct. Now we will go by what has been stated there. You can't impute something, you can't substitute something. It simply says opposite party number 1 to freshly consider the revocation of suspension in the light of the allegation made against him. And in view of the order of removal, annexure 8, keeping in view the settled that the suspension and removal of an is a drastic action. So both revocation of suspension and removal, both has to be freshly considered. Correct? Now, what happened thereafter?
The direction is, if this is not done within a particular time frame.
Where it is?
page 71.
Paragraph 8. The result, the writ petition stands before.
Immediate revocation shall take effect.
Only to give effect to that much the idea was filed because 4 weeks crossed, 8 months passed. After that, they filed so that revocation only will be given effect to implement that much.
How can, in a disposed of matter, the court can pass an order? Tell me. You have to initiate a separate proceeding for that. The moment the court disposed of the final proceeding, it becomes functus officio and remains in cessation of a powers under a very limited jurisdiction. Correction, section 152 of the CPC for correction of the ministerial review. Only modifications or a clarification.
Which was sought in the last occasion, last week, your lordship heard the matter, and in which your lordship directed me to find certain decision in respect of that, and I found certain thing.
What decision? That it can be done. Show us. Let me also know. What is this?
Sir,
Who has given?
the latest is discussed in March 2026 in the.
Let us see. I think last judgment was. What is this? How this is first line itself distinguishes.
Correct.
You can definitely make an application for recall of an order under section 151 of the court or under order 9, rule 9 of the court.
Also,
so that is permissible because there is a provision. I simply wanted that how an interlocutory application be entertained.
Only for implementation of last part.
Can it be done?
Because that
Implementation.
So the final because it said because I was removed, your lordship, and it was passed that within 4 weeks, if a reasoned order is not passed by the state, then.
So if it is an automatic effect,
Sir. But sir,
then for that the interlocutory application is fine.
Sir,
If they do not give an effect, it may invite a different consequences.
Sir, the prayer of each IA is examined before. It's not like not every interlocutory case is not applicable.
No.
Only when
Where is the interlocutory order?
That is
That order?
page 18,
No. What is the date of the order?
10/3/2020. The lordship will say that
You did not appear.
nature of the IS
will be appeared.
No response from opposite. Opposite party number 1 is a state.
So here, my lords, in effect,
Just
for
one
non
minute.
states inaction, my lords, we have been made some.
Where is the order of the appellate court?
My lords, that decides.
Annex of 5 years.
3.
WA.
Annex 9 years.
Annex 9, page 70.
73.
Yes, sir. Annex 9 में kindly receive.
PDF page 19.
Who is the writ petitioner?
I am the writ petitioner or the elected representative Sarpanch. Your lordship, I was removed under 115(6).
Don't, please. You are
I'm the private opposite party. in the writ petition.
You challenge that order.
I challenge that order, page 74.
And we're taking a ground that the time limit which is fixed there is too scanty.
Yes.
So on that score, this court says that it is the state who has been entrusted has not come forward.
Yes.
How can you come forward? And then did not interfere.
Did not interfere, and in the operative portion, the entire writ appeal was dismissed.
Now, what is the another judgment? One, I got it. Another judgment, sir.
The 2026 at page number 8, the nature of IA is discussed, Your Lordship. Not whenever there is a prayer for ad interim. The judgment that is there right now with my lord, its miscase application is to change the nature and circumstance of the final order of the writ appeal. They are asking for protection in a disposed of case. They are asking for certain kind of change of order. But in this case, where the law,
no, sir, this is not, because
the direction
in this case it was a different.
So the law is executory in nature, and when there is an impossibility for implementation, because after 4 weeks of lapsing, I had no other option apart from giving this law an effect. For example, if that is not taken into consideration.
So if there is any statute like a Contempt of Courts Act or a statute which permits another writ petition to be filed for enforcement, you will say that I will go into the same court.
In respect of contempt also, Your Lordship, when there is only slight implementation, it is a discretionary thing, Your Lordship. If my lord will see that if that IA I have filed, if that
So
IA
there is already a writ petition is also maintainable for enforcement of the order.
The writ petition stand of the.
I am asking you, a writ petition for enforcement of an earlier order of writ petition passed in a writ petition is maintainable. Are you aware of those judgment of the Supreme Court? Not aware.
In respect of contempt also, contempt power also.
There is a judgment that even if the contempt application is dismissed, the writ is maintainable.
But if contempt but cannot be used to execute an order, Your Lordship. If I file this
What are you talking about? The contempt is both.
2000.
It has a dual function. Not only the punish, but also to see that the order is implemented.
On 2000 live law 2024 case. I have it as a soft copy.
But I have a larger bench decision than I do not know it's a lower. I know the larger quorum judgment which will prevail.
My ground for only sitting is.
I believe that into 2024 judgment also does not talk about that it is only a contemptuous act. Court cannot seek or cannot enforce the implementation. I will be surprised if you give me a judgment.
I can actually.
Sorry, I will be surprised because I understood wrongly because it can do both.
So I have citation for that. 2024 live law SC page 971.
What it says?
It's where contempt power of application for contempt of power cannot be used to give execution to a order, Your Lordship. I maybe can be seen.
I think you are a wrong understanding or a wrong reading of. I do not believe that this judgment may come. I do not believe. Cite a judgment.
From our side, we have given the latest judgment. Ajay Kumar Jain.
This case is not applicable. This case is not entertainable.
Not entertainable, and they have given a lot of guidelines, and thereafter Vidyut they have.
Vidyut Vitran has been given.
So the nature of the IA may be seen in those cases. The nature of the IA is trying to change the final order after a disposal of case.
Let me just complete. Now, my lord will see Ajay Kumar Jain.
That we have followed it. Day for yesterday.
My lord. And following that, the Delhi High Court has also followed that. And original judgment began from 1987. Brahmdar. That also we have.
180 Mohala case was also.
Union of India versus Brahmdar Sharma. that we are prosecuting. So from this is the first judgment. And subject to what my friend Dean said, I think this is the settled position that IA for implementation is not maintainable unless you show that it is impossible to get it executed. In our High Court, execution under the High Court is also permissible. Execution petitions following Order 21.
This idea was not simply allowed. It was heard few times. I did, in fact, even the John single judge also questioned the IA lordship during that time, and I had to just show one thing that it is only for giving effect to the final order.
When we become office officials, we pass further order, except extending the time. I think that is the only thing,
Extending the time or typographical error. Here they have clarified this 2024, and this also, if your lordship would see Ajay Kumar Jain, the facts are almost similar.
Show me that live law.
What is the name of the party?
Charuranya Kantraj versus P. Raviku. Charuraj Kantraj versus P. Raviku. Charuranga Katraj versus P. Raviku.
You got it. What is this? Who's judgment?
Recent, sorry. It's roads.
How many pages are? Oh. What did it say?
or just a caption heading you have seen and submitting? Have you gone through entire judgment? You have. See, in the instant case, after having kept quiet for a period of almost 7 years, from 21/11/2024 till 12/8/2021, till filing of IA number so and so, no effective steps were taken by the state and its instrumentalities to implement the orders of this court except exchange of interdepartmental correspondence, which is already noticed here. These are factually it is different.
Right, whatever I think. Your Lordship, in short, in this case, I was the writ petitioner. I was the elected representative. Not first time, sir. 3 times I was elected before. This was the 4th time. I was removed on 115(6)(a) for not convening
Sir,
payment.
whatever, we are not concerned on the merit. We are simply concerned on the applicability or a procedure which is being adopted
Thanks.
by you.
Thanks.
To be recognized procedure or not a recognized procedure. We are on that. It does not mean every time when you come, even a court does not have a jurisdiction, be it plenary, be it the territorial or a pecuniary. You will say it is simple implementation, do it. How? The court exercises the powers within that contour of the jurisdiction. Can it go around? Above it? Can it jump it? This is what is a main thing. Once it becomes a functus officio, only for a very limited purposes, it
Sir,
do not have the power.
my IA is for only to saying yes and nothing else. My IA is to just whatever the order has already been passed, just to say a yes, nothing else. No change in nothing.
It
The
will,
nature
it,
of the
will,
IA.
it will open a Pandora box for all and sundry to misuse it. The way you are suggesting, I think it would be inviting such an anomalous situation which will be uncontrollable.
Because of that, this
Cannot be done in this way. Yes, why you are not doing it? Let us go. Forget about what is there. Why you are not doing it?
now they have done it. That is the when
What?
that they have issued a notification of further notification in the reinstatement.
Reinstatement means?
Reinstatement of he was reinstated to his post. So in the meanwhile, the government has issued notification ahead of this order. The notification, the office notification.
No, there was a direction for taking a fresh decision or consideration. Have they passed an order?
That's what he's saying, that the decision has been taken.
Okay.
No, we have not passed an order on merit. The order which is impugned, that they have implemented. Reinstating him in service after this writ appeal was filed. The next day, since stay was not granted, they have reinstated him in service. But on merits.
But consideration in terms of the order has been made.
No, consideration in terms of the original order, whether he has conducted those 3 meetings or not, that has not happened till date.
Yes, ma'am. Yes, Your Worship. That has been made. We have filed an appeal in the state. We had come to the High Court once. The High Court gave us a liberty to file an
Sir,
appeal.
after this order of the single
Yes.
bench, I just wanted what happened.
Yes, sir. An appeal.
After the order of the single bench, tell me what happened. Except that they challenged this order before the appellate court.
Yes, sir.
The appeal got dismissed. That's all. Thereafter, what the government did, tell us.
If the government's instruction
I'm just asking you what the government has done.
then I will withdraw my notes. If he has conducted those 3 meetings, then I have no case. So that our specific case before your lordship is that those 3 meetings are not.
We are also not concerned with that.
So that part was.
We are simply concerned there was a direction for fresh consideration.
That hasn't happened.
That's all. We wanted whether the fresh consideration has been done or not.
But I,
So, yes, we can't do it. We are deciding because I think we should set at rest many issues which are grappling in the mind for all time to come.
The previous rate appeal also, your lordship had clarified that the state had the locus to.
Sir, that was on a different. He came
Currently,
and we say that how
currently
you
Kavita
stand in the way of fresh consideration.
Kavita Saha is not directly affected by the result of the election also, your lordship, because he is not the person who is second or third, not even a participant. So my case was, if my lord will allow me, the part where 3 meetings are being considered, the 3 meetings part was considered in the state's appeal.
We are passing a order of stay, and in the meantime you do it.
Yes.
The question which
Item 26.
Order effect easily in March 2026. Before I go to the.
For face consideration, go there, let them decide what.
Just allow me, just very briefly.
No.
I will be very brief in my friends.
I am not afraid of a brief. No. I am saying, asking, it is no decision has been taken, reverted for consideration. Why?
Once I place the matter, already a decision is taken, and this will be a post-decisional hearing, and the post-decisional hearing, the fate is already known, and that's what it is always been depicted. The decision was taken without uploading the pre-decisional hearing. Once they challenge that, then comes the reason, and then they trace out
that has been caused.
No, but that has been caused, but again, the question here is that, my lord, of that jurisdiction. That this is a conducted by an authority which doesn't possess the jurisdiction. That's precisely what.
Take a plea of jurisdiction, you go and take, they will decide.
See, the so-called has been issued without a resolution to. But what I can give here, logically
says that order has been passed. There is a violation of the principle of natural justice noticed.
such provisions for them to take this decision, and I have taken this.
What is this?
This is the so-called they have issued. This is the so-called they have issued to me, and
go and give an answer.
There is absolutely no allegation against. What can see that?
Whatever, is it so vague? It is so that you cannot understand. You know the scope of the writ against the show cause.
No, Lordship will protect me for a while after taking a decision, say a week or two. I will be otherwise, what is happening, my lord? Immediately I will be after serving 2 years, putting up the best upon performance, and my APR in the 2 years is good. I have been serving in the higher post for 2 years and no fault of mine. They have themselves decided that is no fault of mine. They are now going to revert me. And your lordship, they have already taken this decision. Part of the decision has already been implemented. They have stated here so. And directly I am taking to that position. And your lordship, one fact here, lordship, kindly see. This committee which taken the decision has no jurisdiction to take it. This whole thing started in 2021 when they amended the law. The recruitment rule was amended in 2021, giving an accelerated promotion through limited departmental promotion examination. And it is only meant for 10% of the total vacancy. Now, when I appeared there, I became qualified. I was granted an appointment in the higher post. I saw there, all on a sudden, that impugned order itself.
It's very clear what we want. Without hearing, without any initiative. Now,
And there is no unblemished here. And in the meantime, there are 2 annual appraisal, and that 2 annual appraisal is also outstanding.
Oh, I understand, sir, but that is what the order is caused without showing you a show cause, without giving an opportunity. How can they proceed and revert you back to your feeder post?
Well, that's number one.
So now they have issued you a letter. He says that you come, give your answer to it. They have to say that what wrong there has been committed, what has been. Can the mistake confer an absolute vested right?
Well, the mistake is here that the vacancy is not there. They are saying.
So whatever is there, whenever the vacancy has arisen, they will promote you.
No, vacancy is there, my lord. That is
so
what.
Whatever, so you go You go and apprise them that this is a vacancy, this is available, you can't say.
Imagine everybody here has been involved. The persons who has filed the counter affidavit has putting me through the notice. The person who defended the order has putting.
Your order, which affects your right, has been caused by the court. The court has correctly said that this order cannot stand being violative of principle of natural justice. Yet you are agreeing and filing an appeal.
Agreed by the fact that
Said that initiate a proceeding, you must give them an opportunity of hearing. They are giving opportunity of hearing.
No,
sorry.
It's a one judgment.
Yes. Predetermined motion, judgment, I will distinguish. Predetermined motion, judgment, you will do fighting.
Predetermined, madam.
Good.
It is that post decisional hearing, madam.
That is what is the here that they have already taken.
Here it is admitted in the order. Here it is admitted all through.
I will consider this judgment here and now. I'll consider this judgment here.
This mistake is also in this case.
What?
Here this is the also on the same premises.
No, definitely not.
Let's talk better first. So when document have paragraph 13. The order sheet fixed. May I just place on that? Part of the decisions they have already implemented.
No, sir.
Part of the decision they
No,
have
sir.
implemented.
I will decide. This is the judgment you want to sign.
Let's make kind of that.
I will consider paragraph 12, 13, 17, 18, I have seen. I've seen.
The post-decisional hearing was not called.
I have seen that. What was the factual background? I will just indicate here in this judgment. What is meant by the post-decisional hearing?
Man, that's number one. Number two, my lord. Number two is that whether
you go there, you place your case, we will make an observation that they will not be swayed by any other factor. They will be impartial. They will decide independently on the basis of the record what more you want.
One small point, my lord Allah. Because inadvertently what has happened is the impugned order is in two parts. Part A is the promotion order of the private party who was supposed to have got the promotion. Part B is the reversion order. So what the learned single judge has done inadvertently also caused party. So that my lord may kindly.
No, you are not in appeal.
My lord.
Sorry.
Then my lord may grant me the liberty once the order.
No, sir.
Modified. Because before I could.
Sorry, we can't do it. The scope is very limited. He has come. I was really surprised after looking that he being a successful, why he is still coming before us.
That was not in
No.
prayer of in the writ also. I would
No.
apply for modification.
Whatever be, then if you have not come, then what can I do?
But I had no chance because the writ appeal was filed within 6 days. So before I could file a modification application, this happened.
Sir, the case is very simple. He has been promoted. Thereafter, the authorities found that the promotion is somehow erroneous. They, without giving in our opportunity, without issuing any notice, without doing anything, reverted him to his original position. He challenged that order in the writ petition. Single bench says, how can you do it? He's been discharging duty in the promotional post. He was there. You want to revert him without hearing him, without giving him opportunity. Cause the entire order of reverting. And then say, if you want to initiate, follow the principle of natural justice.
Last time,
Still, just imagine, what shall I do?
just to remind your lordship, last time your lordship asked him to take instruction, who is the appointing authority?
Competent authority is the executive director is.
So this is.
He will listen, he will hear the case and he.
At least,
I have no remedy. My lord,
at least
kindly-
to-
No, you can't.
my,
You can't.
my difficulty.
He will not. The scope of the challenge is limited. He has come that there cannot be a post a decisional hearing. We are not interfering it. Other portion which goes in his favor, I will not set aside on your request.
Then I'll file.
And only,
Sorry, we can't.
but only prayer is that instead of assistant general manager, you can say direct that executive director.
It's already there in the show cause.
So,
It's already there. It's already there. No, you can't. How could you?
I understand.
Sorry.
Because I may be given the liberty to file an appeal.
It's up to your statutory right. We can't do it.
Right.
Whether will you write or will you not? Because we have a full court now. Sorry, to equity law.
go to the language.
That is what is it. Wow, that is, yeah, yes, we have an opportunity, why not?
And this is why manager,
Assistant General Manager personal,
Yes.
he has given the notice.
No,
Yes.
the competent authority.
in line with the recommendation of the selection promotion committee and on approval of the competent authority, the executive director, Sri Amit Kumar Ejitu, was promoted and you are revoted. Status that thing now hearing will be done by
Yes,
the same.
Hearing will be done by the same. Directory.
That you have not stated.
My lord, my modified state. It is stated, but if they are not satisfied, it will not be stated.
It will be done by a,
Executive directories.
that's all.
My
Yes. The
system.
देखो We have already said.
And that if the rules are available, they may consider unequitable ground.
What?
Whether it necessitates a reversal or not.
No. We have said impartially, fairly, everything I have said.
Vacancy is available.
Look, it also goes without, it goes without saying that ninth week of
Last week, your lordship, last time your lordship reserved it saying that orders will follow. But it has come up again. There is a judgment by the side judgment of the apex court.
Oh, it came for order so that we can,
The 5-judge bench of the apex court.
who is for the other side? Then given an opportunity to deal with that.
So I am filing it and I am filing a written note. So,
Sir,